The morning they fired me, they thought they were saving $4 million. By sunset, they had triggered a disaster worth more than $6 million, destroyed 2 executive careers, and handed me the most satisfying victory of my professional life. The funny part is that none of it happened because I was smarter than everyone else. It happened because I did something incredibly rare in corporate America. I read the fine print. The warning sign started the moment I walked into the headquarters of Sterling Financial. Normally, the receptionist greeted me by name every morning. That day, she suddenly found the floor fascinating. She wouldn't even look in my direction. Before I reached the elevators, my phone buzzed with an email marked urgent. Mandatory performance review. Conference room 5B. 15 minutes. No explanation. No signature. I had been in finance for nearly 2 decades. You develop instincts after enough years in executive meetings. You learn when numbers are bad, when deals are failing, and when people are plotting something behind closed doors. As I walked through the hallway, several employees avoided eye contact. One manager I had personally mentored practically ran into a copy room to avoid speaking to me. That was when I knew someone had already decided my future. The timing made no sense. My division had just completed 12 straight quarters of growth. 3 weeks earlier, I had closed the largest account in company history, a contract expected to generate nearly $30 million over 3 years. The company celebrated the win publicly. Investors were thrilled. Revenue projections were soaring. And somehow I was being called into an emergency meeting. Before heading there, I stopped at my office. Inside a locked drawer sat my employment contract. Most executives sign those documents and never read them again. I wasn't most executives. The previous year, during contract negotiations, I had insisted on adding several protections. One of them was buried inside Clause 14B. I pulled out the contract and reviewed it carefully. Still there, still signed, still enforceable. A small smile appeared on my face. Then I placed the document into my leather portfolio and headed toward the meeting. The conference room looked exactly like I expected. The blinds were closed. No laptops were open. No reports sat on the table. Waiting inside were Melissa from Human Resources and 2 HR representatives who looked uncomfortable enough to be anywhere else. Still there, still signed, still enforceable. A small smile appeared on my face. Then I placed the document into my leather portfolio and headed to Melissa gave me a rehearsed smile. Rachel, thank you for joining us. I remained standing. Of course, she cleared her throat. We've completed a restructuring review. Unfortunately, your position has been eliminated effective immediately. There it was. No discussion, no warning, no explanation, just termination. I nodded calmly. Understood. Melissa blinked in surprise. She clearly expected tears, anger, or negotiation. Instead, I handed over my badge before she even asked. The meeting lasted less than 5 minutes. Just like that, my career at Sterling Financial was supposedly over. What Melissa didn't know was that they had terminated me less than 24 hours before my executive equity package vested. And that was a very expensive mistake. Because Clause 14B specifically protected against last-minute terminations designed to avoid executive payouts. If the company terminated me without cause within 24 hours of a vesting event, they wouldn't avoid paying me. They would owe me even more, much more. Instead of heading toward the parking garage, I went directly to the legal department. There I met Ethan Walker, an attorney who had worked with me on several major negotiations. He looked shocked when I explained what happened. They terminated you today? Effective immediately. What reason did they give? Restructuring. His expression darkened. I opened my portfolio and placed the contract in front of him. Read Clause 14B. He scanned the page once, then twice, then a third time. Finally, he leaned back in his chair. Oh no, that response told me everything. They triggered it, didn't they? I asked. They absolutely triggered it. The clause was simple. Any involuntary termination without documented cause within 24 hours of a scheduled vesting event activated accelerated compensation protections. That included my bonus, additional equity compensation, salary multipliers, and legal damages if challenged. Ethan rubbed his forehead. They were trying to save money. I know. They just cost themselves millions. I know. Within minutes, he began forwarding documents and notifying senior legal staff. I wasn't interested in revenge. I wanted enforcement. There was a difference. Revenge is emotional. Contracts are mathematical. And math doesn't care about feelings. Before leaving, I made one more stop. A young legal analyst named Emily worked on compliance reviews. Years earlier, I had mentored her when she was an intern. She was brilliant and detail-oriented. I handed her a copy of the documentation. Take a look. 5 minutes later, she stared at me in disbelief. They actually fired you inside the protection window? Yes. Did Melissa sign these amendments? Every page. Emily shook her head slowly. This is going to explode. That was exactly what I expected. By lunchtime, panic had already spread through the executive floors. Melissa was frantically searching for documentation that could justify my termination. There wasn't any. My performance reviews were spotless. I had never received disciplinary action. No warnings existed. No complaints existed. The company had fired one of its highest performing executives without cause one day before a major compensation event. Legally, it looked terrible. Then things became worse. Senior counsel reviewed my contract. Then outside counsel reviewed it. Then the compensation committee reviewed it. Every single person reached the same conclusion. The company was trapped. Late that morning, I received an email from the board's lead attorney. The message was short. They had received my documentation. They were reviewing the matter immediately. That told me everything I needed to know. They understood the danger. Meanwhile, executives were gathering inside emergency meetings. The CEO, Brandon Cole, initially dismissed the issue. According to several people inside the company, he repeatedly insisted I was bluffing. That confidence lasted until legal counsel placed the contract in front of him. Then reality arrived. The clause was clear. The signatures were valid. The timestamps existed. The documentation trail was perfect. Most importantly, Brandon himself had approved the amendment during the previous year's negotiations. When he finally realized what happened, the room reportedly went silent. The payout wasn't for $1 million anymore. Internal calculations placed the number above $6 million, possibly higher. The board immediately demanded explanations. Why was legal not consulted before termination? Why was no cause documented? Why had nobody reviewed the contract? Those questions produced very few answers. Several executives attempted to argue that they terminated me before the vesting date. Unfortunately for them, that argument was exactly why the clause existed. The language specifically prevented last-minute termination tactics. In other words, they had walked directly into the trap the clause was designed to stop. Later that afternoon, I received a call from David Harrison, a board member I respected. His voice sounded exhausted. Did you expect this to happen? I looked out across the city skyline before answering. No, I expected them to honor the agreement. Silence filled the line. Finally, he sighed. The board just received updated calculations, and the payout exceeds $6 million. I wasn't surprised. David continued. Brandon keeps insisting this was an oversight. That's unfortunate. Melissa claims she never fully understood the clause. She signed it. Another long silence followed. Finally, David asked the question everyone seemed obsessed with asking. What do you want? I smiled. The answer was simple. Nothing. He sounded confused. Nothing. I already have a contract. That was the part nobody understood. I wasn't negotiating. I wasn't threatening. I wasn't demanding anything. The agreement already existed. The outcome was already written. All I had to do was wait. Over the next several days, the situation worsened for Sterling Financial. The board conducted internal reviews. Legal teams prepared assessments. Executives scrambled to protect themselves. Every investigation reached the same conclusion. The company had created its own problem. Eventually, a settlement package arrived. The final number exceeded $6.5 million. The payment was approved. The matter was resolved. But the financial loss wasn't the most significant consequence. Melissa resigned shortly afterward. Officially, she left to pursue other opportunities. Nobody believed that explanation. Brandon remained with the company, but his authority disappeared almost overnight. He was reassigned to a newly created role with an impressive title and very little actual power. Corporate exile disguised as promotion. As for me, I moved on. Several firms contacted me after hearing rumors about what happened. One investment company offered something far more valuable than another executive title: partnership, ownership, a real seat at the table. Months later, while sitting on a hotel balcony overlooking the Austin skyline, I received the final confirmation that the settlement had been completed. The money had arrived. The case was closed. The careers that tried to remove me had collapsed under the weight of their own decisions. I thought I would feel victorious. Instead, I felt something else: clarity. For years, I had helped build a company that believed it could replace anyone. They assumed loyalty was unlimited and consequences were optional. They thought they could remove the person who generated millions in revenue and simply continue forward as if nothing happened. They were wrong, not because I fought them, not because I attacked them, because I prepared. The truth is that success in business isn't about being the loudest person in the room. It isn't about power, titles, or corner offices. It's about understanding the details everyone else ignores. While executives focused on presentations, headlines, and quarterly celebrations, I focused on the contract. While they chased appearances, I protected myself. And when they finally decided I was no longer necessary, they discovered something too late. The most dangerous employee isn't the one who threatens retaliation. It's the one who already planned for betrayal. The day they fired me, they believed they were taking away my future. Instead, they funded it.